One of the major arguments for and against judicial review, Alexander Hamilton claimed that interpretation of laws is proper in particular province of the courts. Do you agree or disagree? What are the advantages and disadvantages of appointed life tenure branch of government overturning laws passed by identified elected bodies? Whenever you're ready, you can begin.
In the 1953 case, Brown v. Allen, Justice Robert H. Jackson concurred that we are not final because we are infallible, but we are infallible because we are final. Justice Jackson recognizes the potential weaknesses of judicial review while acknowledging the importance of establishing permanent precedent by upholding and protecting the fundamental principles of the framers. The idea of judicial review did not start with Chief Justice John Marshall's decision in the 1803 case Marbury v. Madison. It began with Plato and ancient Greece and was indoctrined into British common law with Dr. Bottom's case in 1610 by stating that decisions made by judges were superior to the legislation of English Parliament. Through British common law, the tradition of judicial review carried into colonial American customs.
Some argue against judicial review by capitalizing on the fact it is only an implied power in the Constitution, and considering the judges to be the ultimate arbiters of the Constitution could lead to such a biased oligarchy instead of a republic. President Thomas Jefferson expressed this concern in his 1820 letter to William Jarvis, stating, "Justices have, with others, the same passions for party, for power, and the privilege of the court." However, the arguments for judicial review, such as protection from political pressures and curation of institutional knowledge, far outweigh the arguments against. Additionally, as James Madison asserts in Federalist 47, for a constitution to be free, it meant, at a minimum, that it had to have a genuine separation of powers. Judicial review allows for the court to be truly independent of both the executive and the legislature.
Lifetime tenure shields judges from the political pressures of our nation. Before the 1954 case, Brown v. Board of Education, Democratic majority supported racial segregation. Justices were able to set a new precedent in favor of civil rights, despite the fact that this was an unpopular viewpoint. Former member of the KKK, Justice Hugo Black helped overturn the 1896 case Plessy v. Ferguson with this ruling, establishing that separate but equal is still inherently unequal. Justice Black went on to dissent the upholding of McCarthyism in the 1951 case Dennis v. U.S., and later espoused the separation of church and state in the 1962 ruling Engel v. Vitale. As the judicial branch is a life-tenured appointment, Justice Black did not have to fear being voted out of office and was protected from potential impeachment by Congress through the Good Behavior Clause of Article 3, Section 1.
The potential political problems of lifetime tenure sprouted from the same situation that led to Marbury v. Madison. President John Adams, after the Judiciary Act of 1800, expanded the federal courts, nominated dozens of judges to check Thomas Jefferson and his incoming party. The Democratic Republicans reacted to the act by trying to rid the Constitution of lifetime tenure. Liberal giant of the Roberts Court, Associate Ruth Bader Ginsburg, now 83, has faced 3 bouts of cancer while sitting on the bench. Yet, she continues to pass and defend landmark decisions. It is left to the other judges to maintain the court, as they are held by an unwritten mechanism to check the continued health of Justice Ginsburg.
In Federalist 78, Secretary of Treasury Alexander Hamilton claimed, "The interpretation of the laws is the proper and peculiar province of the courts." Hamilton argues that the courts are the realm for the judges as they are more educated in the plan outlined in the Constitution than the average American citizen. While there are arguments against the judges and their province, we relinquish the fear of their potential biases and trust in them to put the Constitution above all else. Hamilton's support of judicial review articulates, "No legislative act, therefore contrary to the Constitution, can be valid. Judicial review ensures public authorities act in ordinance with the law, and that all legislative acts reflect the tenets and ideals upheld in the Constitution, and are in ordinance with the unalienable rights of life, liberty, and the pursuit of happiness, as outlined in the Declaration of Independence." Thank you.
357.
Yeah, so in your testimony, you guys talked about the importance of lifetime tenured judges, but I want you guys to maybe kind of take a position on the counter argument of that. You've got a bunch of 80-plus-year-old people in this courtroom who are not familiar with a lot of the technology, the nuances of present-day society. Is there are they unfairly representing a certain proportion of the population, i.e. old people, and not maybe representing younger generation such as yourselves?
I think they're fairly represented because each Supreme Court justice has around five clerks that they have, and these clerks are fresh out of law school. They're young. They know what's going on in modern society. They know this technology, so they are there to aid the Supreme Court justices in helping with modernizing them.
And they are modernized because in a lot of the cases now, I mean, with Ruth Bader Ginsburg, she just decided in Okerveld versus v. Hodges, which is a very controversial case about the rights of homosexual couples and everything. And so they are aware of what's happening currently in the U.S. because they still have to make the decisions about what's happening in the U.S.
I would like to say that justices are not meant to be a representation of the public. They are meant to be the educated few. They are meant to be the elite. They are meant to be smarter than I am, smarter than the majority of the population, because they're delivering such strong opinions and they are making decisions that will affect our nation for arguably the rest of time. And so I would like justices who are far superior than I, who are not reflective of myself, because I wouldn't personally want a reflection of our population to be making these decisions for our nation.
But again, this does go back to the fact that they do make pretty keystone decisions that do have lasting effects, hopefully. I mean, they get overturned. But generally that these judges have wield great power, and for them to be old and potentially incompetent, we have no system in place to measure how well they are mentally capable. We don't have any real checks on keeping them, within what's okay for them to be doing. That needs to also be addressed.
To expand on Maddie's statement, there's a judge in Nevada named Elizabeth Hubbardson who fell asleep on the bench, but we have no means of removing her because there's nothing in the Constitution that says we can.
What about good behavior clause?
Mr. Clark pretty much told us that was irrelevant. Well, I know.
Just say it's irrelevant.
Okay, well, it's irrelevant. So, it doesn't have really any weight to it. Like, there's no, basically only a judge can be taken out if they've committed a felony, and then there's no,
The good behavior clause is essentially lifeless. It has no meaning, it has no way of being acted out. But there is, the only way to keep justices really keeping them honest and keeping what our courts intact is the unwritten mechanism held among the other justices, that they will let each other know when they need to be eased out, that they will sort of hold the heavier cases until they reach a panel that is of 9 people that are all of sound mind and body to be able to handle this. So although there's no actual check, the other justices provide a reasonable safety net for any sort of instance, such as what happened in Nevada, to occur on the Supreme level.
You guys hinted at, but didn't expand on this. I'm curious to know how the idea of judicial review began with Plato in ancient Greece. Can you please explain what you mean by that?
Plato was a philosopher, and so pretty much his job was to think of ways that government could be run that would succeed. And one of the ways that government could succeed is with a judicial system. And so he probably thought of the first ideals that are now in our judicial system today.
It was originally Plato's idea to have the educated philosophical elite run the nation, that they should be the ones in charge of government, that they should be the ones making the decisions for the rest of the people, as they are the geniuses of their time. So this is reflected in our judicial branch because we choose the most educated, the people who have had the most opportunity in their life to reach the point that they will be able to make decisions for our country.
We're good. Yeah. Let's go back to that. Let's go back to that Plato thing.
Last time you said it was
I
Aristotle,
want,
but
I want